Medmarc webinar series. I'm Heather Thompson, Director of Internet Marketing for Medmarc. On behalf of Medmarc and today's presenter, thank you for joining us. I'm so pleased to kick off today's presentation titled Litigation and Claims Trends for the Life Sciences Industry, the 2018 Year in Review and Forecast for 2019. In this year's highly anticipated annual year-end wrap-up, Sonia Valdes, Medmarc's Vice President of Claims, and respected product liability defense attorney Adam Porter with Butler Snow will summarize the state of the medical industry, from the Court of Public Opinion to the United States Supreme Court. Without further ado, I am pleased to turn it over to Sonia, who will begin today's presentation.
Thank you, Heather, and thank you for joining us. Welcome to Medmarc's annual webinar summarizing the significant developments in life sciences from a litigation and regulatory perspective in 2018. As in keeping with past webinars, we will also provide our prognostications for 2019. I'm Sonia Valdes, and I'm excited to be presenting this for the 5th year in a row. We have a full agenda, so away we go. First thing I'd like to talk to you about is attacks on the medical device industry. 2018 was open hunting season on the medical device industry. The FDA and its approval process was attacked on several fronts in legal cases, but also in print and television media. Critics argue that the FDA is far too cozy with the medical device companies that it regulates. Partially responsible, perhaps, is the current administration's stated objective to cut red tape/bureaucracy, increase the number of approved products, and decrease the time spent in reviewing the submissions for approval. This has been viewed as very favorable to the industry. Also potentially responsible for this attack was the appointment of Dr. Scott Gottlieb as FDA Commissioner. He is viewed as an insider with connections to the medical device industry from his days leading hedge funds. In addition to discussing these attacks on the industry, we will also address responses to these industries, which I personally consider to be woeful. So, the first attack on the industry occurred in a book published in December of 2017 by Gene Lenzer. It chronicles the fight of a man who had severe seizures, who was implanted with an FDA-approved device, a VNS, a vagal nerve stimulating device, which he claims nearly killed him. The book received terrific reviews and was widely sold. A few things. Gene Lenzer is not a medical doctor. She is a physician's assistant and an investigative medical journalist. She's a contributor to the British Medical Journal and the New York Times. One of Lenzer's premises is that more studies are needed to test the effectiveness and side effects of VNS therapy. The FDA conditionally approved it. The company did post-market studies, 5 of them in fact, but Lenzer claims, incredibly I might add, that the company told her they didn't track deaths as part of their study. She attributes many deaths to this device. And here's the first bias I'm going to lob at you. Never mentioned in her book is that this product is intended for those patients who are not candidates for epilepsy surgery and who have drug-resistant epilepsy. There is a high likelihood that these folks would have died from a seizure, not from the VNS device. Lenzer also argues that 70 million people are implanted with these medical devices, no clinical trials, and more importantly, no follow-up by the FDA on cleared products requiring post-market studies. She argues that studies aren't being done and the FDA isn't requiring anyone to do it. This is biased because she argues at one hand that most companies aren't doing it and cites the number as 40%. If 40% is to believe, it is a large number, but is not greater than 50%. Her second tenet is that no one is tracking the rates of harm, only numbers. For example, is the allegedly defective product causing injury in 1 in every 10 implants or 1 in every million implants? That's a big difference. She also argues that many of these implanted products are difficult to remove and specifically cites mesh. Lastly, one of Lenzer's premises is that most of the research is self-funded by the medical device industry, not by the government through the FDA. She accuses the industry of suppressing bad outcomes. She argues that political pressures have sometimes overridden the recommendations of science panels not to approve a product. Shortly after the Lenzer book on the heels of it came The Bleeding Edge, a Netflix documentary. The documentary spans 2 hours. There are interviews with patients, but none with the FDA or any manufacturer, although they did submit written responses. The documentary focuses on products approved by the 510K process, the substantially equivalent process, which they claim is the approval route for 98% of medical devices. The documentary argues that the 510K process is flawed, dangerous, and must be replaced. They argue that there is no meaningful review by the FDA, no clinical trials, and the predicate device can actually be a defective product that was recalled. For example, they cite metal-on-metal hips and mesh. The documentary also argues that medical device companies paid doctors more than $8 billion in stealthy ways, such as consulting agreements and teaching or sponsoring fellowships. They claim that these financial incentives encourage physicians to use the latest technology, even when unproven and when there is no apparent benefit to the patient. Bullet 3 on the screen cites robot-assisted surgery as a case where the risk exceeds the benefits. Originally, the Da Vinci robot was approved with a 9-month training program. Now it is only a week. The documentary argues that this is dangerous, but the reality is it's probably safer now because more doctors are likely to go to weekend training than a 9-month training program. So let me point out the bias in a lot of this, the leading edge. I saw it and I couldn't believe it. Number one, and I guess it's most important to me, the documentary doesn't describe the warnings provided with these products or the medical guidance given. Let me give you an example. There's an orthopedic surgeon in Alaska who raced bikes in 100-mile races before his metal-on-metal hip implant. He then raced 200 miles after the implant. I can assure you that there are strict warnings on the metal-on-metal hips for certain strenuous activities, and he was probably advised by his doctor that he should have given up bike racing. A second huge bias, the documentary repeatedly uses Dr. David Kessler, who's a former FDA scientist and head, who is getting paid very fat fees to serve as a plaintiff's expert against medical device companies. And lastly, the documentary never mentions the hearings that the FDA consulted almost yearly on Bayer eSure, or the nearly 30 studies done by Bayer since the approval of its eSure product. So, what has been the response to the medical device industry? Written responses only, none on camera. I did look to see if I could find private companies who might have commented, and I did find a couple of them. Mark, a private company involved in clinical trials, authored an article citing recent more stringent FDA requirements for clinical data support devices regulated through the 510K process. Their article discussed the post-market surveillance study recently required by the FDA on at least 3 of the products it was testing. Consulting group EMMA attacks the biased nature of the film, states that the FDA is the most stringent regulatory authority in the world. It accuses the documentary of, and I quote, cherry-picking patients with adverse outcomes to market to a population of viewers who are unfamiliar with the FDA landscape. This documentary does a disservice to patients whose lives would benefit from medical devices. That is all that I have found. Surprising in light of a recent poll of those who watched the documentary. The poll found that 77% agreed that the documentary provided a fair depiction of the FDA regulatory process. What I found even more surprising than the poll results was the fact that most medical device companies haven't responded in some fashion to this documentary. And on that note, I'm going to turn it over to Adam for a discussion on conflict preemption.
Good. Thanks, Sonia. And as was mentioned, my name is Adam Porter. I come to you from Philadelphia, Pennsylvania, where I'm currently in a pelvic mesh case, a trial that's going on in the Philadelphia Court of Common Pleas, which is one of the products that was mentioned in that, or featured in that documentary that Sonia was just talking about. So hopefully I can bring a perspective to you guys. So what I'm going to be talking about right now is preemption. Preemption is a very important issue that is fairly straightforward, but is critically important given that our industry is highly regulated by the federal government. And so preemption is pretty straightforward. It's just that when a federal government speaks to, makes a finding, enacts a law or regulation, then a state law or regulation cannot infringe upon the federal government's finding. And so currently there's a case before the Supreme Court that is very important, that is going to hopefully resolve some issues that we've been facing, and that's the doctrine of impossibility preemption. And I'll go quickly through the facts of this case. So this is a Fosamax case, which is an osteoporosis drug, and the plaintiffs in these cases are alleging that the drug caused them to suffer severe thigh bone fractures. And the theory of the case is that the Fosamax labels failed to warn of these femur fractures. Well, the problem for the plaintiff is that Merck tried to warn of these dangers, and the FDA said, no, you don't have to. And so the defense here is clear. The FDA told Merck not to warn of the danger. And so this is standard. It was impossible for Merck to comply with their federal law, and then it's being asked to be held subject to state law as well. So the district court, the trial court, sided in favor of Merck and dismissed the cases. Well, the Third Circuit Court of Appeals reversed the district court and held that had an appropriately worded warning going to the FDA that when Merck inquired into that, then it's possible the FDA would have changed its mind about that. And so the issue before the court before the Supreme Court is pretty straightforward. It's just whether or not a jury should be allowed to speculate as to the FDA finding whether or not the FDA would have found that they should have warned in this case. And the defendants, again, their argument is straightforward. If a manufacturer proposes to warn about a risk, discloses what it knows about the risk, and it gets turned down by the FDA, then failure to warn claims should be preempted. The Trump administration has taken a pretty active stance in this case. The Solicitor General has asked to be heard on this issue. He has a record. Jeffrey Wall has a record supporting preemption, and so that's good for our industry. And it's going to be interesting to see what happens. It's currently awaiting oral argument, and the court, since the last major preemption case in 2009, has had a pretty severe shakeup. Justice Scalia and Justice Kennedy are no longer on the court, and so Justice Kennedy was actually in the majority that was in favor of a lesser standard for preemption in 2009. So having Justice Gorsuch and Justice Kavanaugh on the court will be interesting to see how this shakes out. And that's next slide, please.
And so another disturbing trend in our space is the award of punitive damages in the life sciences litigation. A little recap on punitive damages. Why are they awarded? They're awarded to deter wrongful conduct and punish those who profit from such conduct. It requires conduct that is either fraudulent, malicious, intentional, willful, or wanton. It must be oppressive. It must be a very high level. This particular trend is truly frightening, especially in our space. The Supreme Court has weighed in on the availability of punitive damages in at least 2 cases. Both of these cases have addressed the required relationship between compensatory and punitive damages awards, although the court punted to the states and didn't mandate what the right formula between compensatory and punitive damages should be. The High Court recommended that the individual states pass guidelines on punitive damages. Some have and some haven't, and this is why we're in the situation that we're in today. The standard for an award of punitive damages is you must meet a standard of clear and convincing, although a significant minority of states merely requires a showing of conduct that is beyond the preponderance of the evidence versus clear and convincing, so it's a much lower standard. Bullet 4, most states have required a relationship between compensatory and punitive. The first one, multiplier, is pretty straightforward. If you have a $1,000 award of compensatory, then the maximum under this guideline would be $3,000 for punitives. Soft cap refers to potentially capping one aspect of the claim, i.e. non-economic may be capped, which is pain and suffering, and economic damages that are available to the plaintiff may be uncapped. So that's considered a soft. A hard cap would be exactly that. No matter what element of the claim, it would be a hard cap of X number of dollars for punitive damages. And then there is no relationship. Let the jury decide, and that is a particular problem in certain jurisdictions. I'm going to give you an example of one of the conduct that the jury found reprehensible. In Risperdal, which is one of the drug cases that came down this year, the jury cited a company defendant's failure to return a single phone call as the basis for its assessment of punitive damages. This occurred in the Pennsylvania MDL. And so let me speak to you a little bit about the types of products that are involved in these punitive damages cases. Testosterone replacement is a happy story. In several cases, particularly in Texas and other cases with tort reform, the punitive damages awards have been reduced by state statutes. In other cases, such as the TRT litigation, the responsibility falls to the judge. In the TRT litigation, Judge Keneally refused to let these questionable verdicts stand. In the first two cases tried, the first case was Mitchell. The jury came back with 0 in compensatory and 150 in punitives. In the second case, Conrad, the jury came back with 140,000 in compensatory and 140 million in punitives. Judge Keneally vacated these judgments as inconsistent and ordered new trials. This decision was widely applauded and led to a tentative global settlement of the TRT litigation within 1 year. Unfortunately, there are not as many Judge Keneallys as we would like in the litigation, in the life sciences litigation world. The case cited in Bullet 2 is very interesting. GranuFlo is dialysis solution manufactured by another party, not the party hit with the punitive damages. The manufacturer is Frenzius, who ultimately ordered a Class 1 recall. 3 patients died from adverse reactions before a recall of the product took place. The allegation was that DaVita should have been aware of the risk to these patients. I find it rare that a company that is not a manufacturer is assessed punitive damages for failure to warn, and in this case, $125 million in punitives was awarded to each patient that died. The case was appealed and led to an undisclosed settlement. We would be remiss if we didn't have a brief chat about pelvic mesh, as we have been in the last few years. J&J actually had a pretty good year. They only had one bad verdict this year, and that was in Indiana for $35 million. They had a positive development. They were able to get a mistrial in the Pennsylvania MDL and a punitive damages award in another case reduced by $15 million. Talc was the big loser this year, and J&J is the biggest manufacturer of talc products. They have 9,000 cases worldwide. The top 3 verdicts in 2018 were all in talc. $4.7 billion with about $4.14 billion in punitives were compensatory, where only $550,000 were awarded to 22 women in St. Louis. I'm going to let Adam speak to you about that, but there was another verdict for $417 million for an individual plaintiff in California, and lastly $117 million in New Jersey. So what's significant about these talc verdicts? Well, number one, to this date, there hasn't been a single study linking talc to reproductive system cancers. Additionally, there has not been a shred of evidence that talc contains any asbestos, yet plaintiffs continue to allege asbestos-related cancers. Lastly, all of these talc cases are in judicial hellholes. So I'm going to turn it over to Adam to give you further discussion of significant verdicts in our space.
Yeah, thanks, Sonia. So I'm going to give you a brief overview of damage caps first before I go back to the talc situation. So, as most of you probably know, there's 2 types of damages that are awarded in most of these cases. They're compensatory damages, and then there's punitive damages. Compensatory damages are made up of both economic and non-economic damages. And economic is generally damages that can be proven with objective evidence, such as past, present, future medical bills, lost wages. You can have expert testimony on future earnings, health needs. You can submit bills, pay stubs, etc. Non-economic damages are things such as pain and suffering, and generally this is made up of subjective, self-serving testimony, and there's a major problem when it comes to placing a value on pain and suffering. And so you can also have jury awards that get out of control when it comes to trying to place a value on these things. Then obviously you have punitive damages, which Sonia just did a great job of giving an overview on that, which is just to penalize, not to compensate the plaintiff, but to penalize a plaintiff, penalize a defendant for intentionally or grossly negligent behavior. And so kind of the issue here, I have some examples of different caps that you'll see throughout the country. I chose Mississippi first. That's where I practice. And so Mississippi back in the 90s was the worst place in America for corporations. There are documentaries written about it. There are books written about it. You have all these mass tort plaintiffs lawyers getting rich on tobacco and asbestos and things like that. And so in 2003, I believe the state legislature enacted what was called tort reform, and they have capped non-economic damages at $1 million, and Medmarc is capped at $500,000. So no matter what happens in these cases, the most the plaintiff can get in non-economic damages is $1 million. And this has really shaped the landscape of Mississippi litigation. There's not as near as many cases filed, and so it's just been really great for corporations doing business in our state as well as getting sued in our state. And then I have other examples here. Indiana is capped at 3 times compensatory. Pennsylvania is more case specific. You have the New Jersey cap here, and then of course California has no cap on either punitive damages or compensatory damages. And one of the issues here, plaintiffs are desperately trying to overturn state legislatures who are enacting these what we call tort reform measures, because they argue, well, of course, it severely limits the amount of a jury award, but also they argue that they're unconstitutional. Some state constitutions provide a right for a jury to determine the facts of your case. And so if that's the issue, then the obvious argument there is damages, like non-economic damages, are questions of fact that are reserved solely for a jury, and that the state legislature has no right in that. There's also a separation of power argument that the state legislature has invaded the judicial branch as far as the remittiture of damages is concerned. And so plaintiffs' lawyers are actively trying to overturn these statutes that provide for damage caps, but so far, at least in Mississippi, we've held off on that happening. Next slide, please. Okay, so I'm going to go through just a couple of the verdicts and as well as rulings that happened in 2018. In addition to all of the significant punitive damage awards that Sonia just talked about, I'm going to talk about a few more that we consider losses in our industry. First, I'm going to go back over talc, because as Sonia said, talc was the biggest loser in 2018, and it was because of this, I believe it was August of this year, this over $4.7 billion verdict. This happened in St. Louis. It was in state court in Missouri, and 22 women sued Johnson & Johnson over baby powder. They alleged that this baby powder contained asbestos, and that this asbestos-laced baby powder caused ovarian cancer. This verdict was the largest to date for Johnson & Johnson, and according to, I think, last quarter's regulatory filings, Johnson & Johnson faces over 10,500 of these talc cases. And so you have the obvious issue here are these large verdicts reveal a major problem for defendants and corporations, and that is the issue of forum shopping. I think Sonia mentioned or referenced judicial hellholes. I'll go a little bit more into that. So there's actually a website out there titled judicialhellholes.org, and it does a good job of kind of reviewing and analyzing the different jurisdictions and state courts in which you really want to avoid as a defendant. And it just so happens that St. Louis, the city of St. Louis, their state courts are ranked 4th worst for defendants in the United States. Bloomberg actually was quoted saying the city of St. Louis courts are known for fast trials, favorable rulings, and big awards. And it appears that's exactly what happened when Mark Lanier, a plaintiff's lawyer from Texas, went and tried this case in St. Louis. And so kind of the factors that go into this for forum shopping for plaintiff's lawyers, one of the main things is the introduction of what's called junk science through expert witnesses. And so either that can be from purely a judicial perspective, or it can be just the law is different in certain states. I'll kind of get to the law issue in a second. There was a major shakeup in New Jersey this year when it comes to expert standards. But, for instance, in talc, and I know Sonia referenced this, but ovarian cancer authorities, you know, they suggest that talc really doesn't play much of a role at all in ovarian cancer. The Ovarian Cancer National Alliance doesn't list talc as a risk factor at all. That this is talc. I mean, ovarian cancer is much more likely to be caused by heredity, obesity, age, things like that, oral contraceptives. And so the American Cancer Society does not even list talc as a risk factor. The scientific findings are all over the map for talc. The most commonly cited by the plaintiffs are some studies done by Daniel Kramer, who is a paid consultant for plaintiffs. That's really the only evidence they have. But more reliable medical studies, including a survey of 121,000 nurses nationwide, as well as cohort studies, they found that there is no significant connection between talc use and overall incidence of ovarian cancer. And so despite these causation issues, plaintiffs were still able to secure over a $4 billion award, and that's largely in part to the admission of this expert testimony. Also in these forums, you have excessive lawsuit advertising, which makes it nearly impossible for defendants to get a fair trial in these cases. For instance, I'm in Philadelphia. A lot of the pelvic mesh as well as Risperdal cases are here. It's on the list, and so of judicial hellholes. There's a lot of places that we commonly practice that are on these lists, and there's a reason. Plaintiffs are looking to get their cases in these jurisdictions. Another significant loss that we had this year would have been the Monsanto case. Monsanto is a Bayer-owned company that makes Roundup, a pesticide, and a groundskeeper that used this pesticide sued the company after he came down with non-Hodgkin lymphoma, arguing it was a simple failure to warn case, and he was awarded $250 million in punitive damages and $39 million in compensatory damages. And so this is one of the first of hundreds of cancer-related cases related to Roundup, and it kind of might show what's lying ahead for Monsanto in these cases. Luckily, it was a small victory in late October this year, about a month and a half ago. The trial court remitted the punitive damage amount down to $39 million. So there's still a $78 million verdict out there, but it's a good bit less than what the jury awarded. All right, next slide. All right, so we discussed the losses. I'll go over the wins. The industry did pretty well with the blood thinner litigation, and also I think Sonia mentioned the pelvic mesh. We had one good result this year in Philadelphia with the mistrial, which we were all really happy about. But so in that case, it's set to be retried next March. So maybe we'll have an update on that next year. But so there's been a lot of success in the blood thinner litigation. Xarelto, which is a blood thinner made by Janssen, and Pradaxa, which is Boehringer Ingelheim. You had defense verdicts, I believe, 2 defense verdicts in Pennsylvania this year for Xarelto. There was a reversal of a $28 million verdict this year for Xarelto. And then Pradaxa, we had 3 defense verdicts this year in 2018, but then we got hit for the first time in October 2018 with just a small verdict. Well, it's not that small, I guess, compared to the other numbers we've been talking about, but it was $1.25 million. And so the plaintiff's theory in these cases, these are what's called novel oral anticoagulants. And this medicine, what it does is it reduces the risk of stroke in patients with certain heart conditions. And so, again, these are failure to warn cases primarily, and it's a failure to warn for risk of excessive bleeding. And so there's no prior medication before these drugs came out required what was called coagulation range monitoring, and these drugs do not require that monitoring. And so the plaintiffs claim that without this monitoring, there's risk of excessive bleeding. And so, but regardless, we've had exceptional success in defending these suits. Okay, next slide. All right, and now I'll talk about the significant rulings. So these aren't necessarily, these are not verdicts, but these are new issues, legal issues that have been ruled upon this year by various courts around the country. So the first case is the Dohme case out of the Seventh Circuit. This is an impossibility preemption case that I talked about earlier with the Merck case, but it also is an innovator liability case. And I'll talk about innovator liability more in a little bit, but essentially what innovator liability is the holding of a name brand manufacturer, holding the name brand manufacturer liable for claims made by the consumer of a generic drug. And so in this case, it's a Paxil case where the FDA told the name brand manufacturer that it did not need to add a risk of suicide to the label. Well, the plaintiff in this case filled his prescription with the generic drug for Paxil and committed suicide shortly thereafter. And so plaintiffs cannot sue generic drug manufacturers, okay, because of the reason, because of the impossibility defense. Like it is virtually impossible to sue these generic drug manufacturers because they are required to use the FDA-approved label by the brand name manufacturer, and only the brand name manufacturer can seek FDA approval to change the label. So in this case, the plaintiff sued the name brand manufacturer despite consuming the generic drug. The jury awarded $3 million to the plaintiff, and the Seventh Circuit reversed and held that federal law prevented. They did not rule on Innovator liability. They ruled on impossibility preemption. That the name brand manufacturer could not have just changed the label unilaterally. That the FDA would not have required that warning. And so that was a great ruling for us this year, and kind of clarified the impossibility preemption issues. Another great case this year was the Bird versus Janssen pharmaceutical case out of the Northern District of New York, which came out a few months ago. This was a Risperdal case, which is an antipsychotic. The plaintiff claimed in this case that the Risperdal caused him to develop abnormal breast tissue called gynecomastia. And so in this case, another failure to warn issue, the plaintiff says that Janssen should have changed the label to include gynecomastia and could have unilaterally, without the FDA's guidance, changed the label under the CBE regulations, the changes being affected regulations. The issue there is that the changes being affected labeling change can only be made on the basis of new information, and it must be information concerning a serious risk. Well, in this case, the district court dismissed these claims and said that the relationship between antipsychotics and gynecomastia had been studied in the literature and textbooks for years. So this is not new information. And moreover, gynecomastia is not a serious adverse event. And so the district court ruled in favor of Janssen and dismissed him from this case, which is another great result. And finally, I know I mentioned this earlier, is the Accutane litigation. It's a new expert standard in New Jersey, which is probably the most significant ruling that came out in 2018. I need to provide a tad bit of context. So there's a federal standard that is widely adopted among most states for the admission of expert testimony. It's called the Daubert standard. Most people have probably heard of that. It's just some factors that courts, as gatekeepers of testimony, need to consider to determine the reliability of expert testimony, and that is to keep out the junk science that I referenced earlier. And so New Jersey, on the other hand, had not adopted Daubert. It had the Kemp standard, which was a more relaxed standard and allowed judges to take a looser approach to viewing evidence, to viewing this expert testimony. And so anyway, the Accutane case came before the Supreme Court after the trial court dismissed many cases. I'm trying to find how many cases it was. It was over 2,000 cases. Dismissed them with prejudice for lack of expert testimony. And the Supreme Court, it changed its course. It said that Kemp was it was getting too fluid, and that courts were not making uniform decisions, and that there will need to be a more clear direction for the admission of expert testimony. And so now in New Jersey, there was an adoption of the Daubert factors, there's four of them. It's whether the scientific theory can be tested, whether it has been subjected to peer review, whether there is any known or potential rate of error, and whether there is a general acceptance in the scientific community. And so courts now have to review expert testimony in motions in limine in the context, Daubert motions in the context of these four factors, which is a pretty significant change for New Jersey. We expect this to, this is the beginning of a more rigorous standard in New Jersey, particularly in toxic tort cases. And we think that this will kind of result in greater consistency in the law pertaining to the admissibility of expert testimony and hopefully be a less attractive venue for plaintiffs in these cases. I'll turn it back over to Sonia.
The FDA thanks Adam. So the FDA had a banner year. It issued a bunch of guidance in 2018. This is meant to be a highlight reel of what I consider to be the more important ones. I'm going to spend a little bit of time in the next two slides addressing the Medical Device Safety Action Plan and the guidance which targets cybersecurity and medical devices. These are probably the most significant of the four I've listed on here. Number 3, the Drug Supply Chain Safety Act for prescription drugs was enacted in 2013 and sets forth the requirements for verification systems to identify and inspect counterfeit drugs. The new draft guidance assists industry in understanding verification inspection site requirements. The directive addresses how to determine, investigate, and dispose of illegitimate or counterfeit drugs and the notification requirements for cleared suspect products. Upon determining that a product is suspect, trading partners are required to quarantine and investigate. There can be no distribution of the product. As we're seeing more and more counterfeit, illegitimate products brought in overseas, this guidance is going to be important. It's going to guide our global supply chains, and our clients should be familiar with this particular guidance. The last one on this page, the 510K Quick Review Pilot, is not a guidance. It was launched in September of 2018 as an alternative to 510K approval pathway. The pilot calls for approval within 60 days of qualifying products, a reduction of 30% in the FDA approval time. The pilot program applies to a very short list of Class 2 moderate risk products. It requires the use of special FDA software, but asks for the same information as the 510K. It's an electronic submission which allows for additional verification. This is just one of the steps taken by the FDA that's going to be viewed as something helpful to the industry and not necessarily to the public. The Medical Device Safety Plan, in the past year, the FDA has focused efforts on a range of initiatives designed to promote quicker access to innovative new therapies and diagnostics. An example of this commitment would be the Breakthrough Device Program, which addresses devices that treat life-threatening conditions and offer significant advantage over existing alternatives. The Medical Device Safety Plan is a 5-pronged action plan revealed in April. It aims to improve ability to better track problem products after approval. So the first step in this is to establish a medical device safety net in the U.S. by using NEST, the National Evaluation System for Health Technology, and also the unique device identifier tracking that is going to be required on all medical devices. NEST optimizes post-market data collection. The NEST data comes from electronic health information sources, device registries, medical billing claims, patient-generated data, and other sources. NEST is an active surveillance and evaluation system that complements the passive surveillance systems known as adverse event reporting currently in place. The UDI is a unique identifier that will be required to be placed conspicuously on all medical devices by 2020. The plan is to track UDIs associated with adverse events. Bullet number 2 refers to methods that the FDA is exploring to improve special controls when the FDA identifies a product containing a risk requiring mitigation by a device manufacturer. What type of evidence will be addressed by these special controls can be post-market studies or even following products for a certain amount of time. The special controls can be conditional approval requiring additional information by the manufacturer. Bullet 3 refers to the FDA's utmost priority, a voluntary modernized 510K pathway for demonstration of safety and effectiveness for certain moderate risk devices by allowing the use of objective performance criteria identified by the FDA to demonstrate substantial performance. They are going to allow real-world evidence, and this is what you've been hearing a lot, to prove the safety and efficacy of certain devices. Lastly, as respects cybersecurity, the FDA is very concerned and will require security updates and patches to be built into a product's design. The medical device manufacturer should provide data about this capability to the FDA as part of the device's pre-market approval. Next slide. The second, what I consider to be most important guidance is the cybersecurity guidance for medical devices. The FDA issued a guidance of the same title back in 2014. This new updated guidance is a direct response to the public threat of hacking. The greater the threat of hacking, the greater protection the FDA is going to want to see demonstrated in its approval process. The FDA has created two distinct classifications for the type and expansiveness of the quality control system to prevent hacking. Our clients will be required to meet one of these two standards and should be familiar with them. So what's on the agenda for the future? Coming soon to a theater near you, the transparency of pricing. The Trump administration and Dr. Gottlieb have made drug pricing a core issue for the FDA. They want to list drug pricing on drug advertisements. Another tool used by the government in conjunction with the FDA will be changes to the Medicare drug rebate program for higher reimbursement schedules for value-based drug purchases. Not new drugs, but those who provide value that have already been on the market will be reimbursed at higher schedules. The government will also be negotiating hefty rebates with drug manufacturers. Bullet 2 refers to enabling legislation to meet the procedural needs of the mammoth 21st Century Cures Act. For example, the FDA will be passing guidance for cybersecurity in telemedicine. And Bullet 3 is to carve out specific guidance on what constitutes servicing versus remanufacturing. These two, servicing versus remanufacturing, are not treated by the FDA the same way and have different requirements. And so I'm going to turn it over to Adam to get into the last portion of our discussion, what's on the horizon.
Yeah, sure. Thanks, Sonia. So I'm going to talk briefly about personal jurisdiction. Over the past couple of years, I'd say 5 years, the industry has had pretty significant wins when it comes to personal jurisdiction with the Bristol-Myers Squibb case as well as the Ballman v. Daimler case. And so I'll kind of briefly go over what personal jurisdiction is. Personal jurisdiction simply is a court's power to haul a defendant in there and make them defend against an action. And so there's really two different types. There's general jurisdiction and specific personal jurisdiction. General jurisdiction just means that a defendant is at home in a state, okay? And so, like for instance, I live in Mississippi. I reside in Mississippi. I can always be sued in Mississippi, no matter where the conduct that I engage in takes place. Specific jurisdiction, on the other hand, is when a lawsuit arises from a defendant's contacts in a state. Okay, so let's assume, for instance, I drive my car into Texas. I have a car wreck there. I can be sued in Texas despite Texas not being my home. That is because the actions that make up that lawsuit occurred in Texas. I purposely reached out and had contact with Texas. So that's just an overview of jurisdiction, and we've had two great cases come out pretty recently. The first is the Ballman case, which simply held that a corporation is not subject to general jurisdiction, the at-home jurisdiction, just because it has a subsidiary in a certain state. And then you have the Bristol-Myers Squibb case, which came out, I believe, at the end of last year, where there were several hundred individuals, I think from 30 to 35 states, that were seeking, compensation for injuries that came from Plavix. And there was nothing that particularly happened in California. That's where the litigation was centered. Anyway, the court said that the only thing that happened in California was just a marketing campaign, which happened all over the United States. Nothing specific happened in California. And so these claims were dismissed. But plaintiffs have been trying to get around these rulings. And one of the ways in which they're doing that is this it's called registration consent jurisdiction. And so their argument is that every state has a registration to do business statute. So when you go and incorporate a new state or create an LLC, you're registering to do business in certain places. And the plaintiffs are saying that by doing that, you are consenting to personal jurisdiction there for all your claims. a lot of these cases have been shot down. They're not finding general jurisdiction there. But Pennsylvania, their statute, their registration statute, actually includes the words that this statute, by registering to do business, you are essentially consenting to jurisdiction there. And in June of this year, in 2018, the Superior Court held that a foreign company's registration to do business in Pennsylvania constitutes constitutionally valid consent to general personal jurisdiction. And so Pennsylvania, I believe, is the only case or the only state to come out and allow this type of jurisdiction. But I think it's something that we can kind of look forward to in the coming years is additional litigation, additional Supreme Court rulings on these issues. Sonia?
And so what discussion would be complete without opioid litigation? And I think we're going to see an expansion of the opioid litigation. I'm going to talk to you where the opioid litigation is right now and what I see going forward. As of today, there are 26 manufacturers, 35 distributors, 45 retailers, plus other defendants named in the opioid mass tort litigation in Ohio. The allegations against the manufacturers are familiar, fraudulent, and illegal marketing practices. Against the distributors are the same as the pharmacies, the failure to prevent theft and diversion, and a failure to report and investigate suspicious orders. I want to focus on number 4. Against the physicians, the allegations are both civil and criminal and include a breach of the professional care, including gross negligence. In the opioid civil complaints, there are fairly detailed recitation of the doctors, some of who are termed key opinion leaders, who went around the country extolling the virtues of opioid medication. These doctors are being targeted, as are doctors associated with pain management clinics who generally prescribe significant amounts of opioids. For example, a pain management doctor in Las Vegas had over 30 patients die in 1 year from overdoses. This doctor is being pursued criminally as well as civilly, and that is one of the trends against doctors. They're not only being sued civilly, many of them are being pursued criminally. So where are we on the actions? There are over 1,600 lawsuits pending before Judge Polster. I've listed some of these here. West Virginia, Kentucky, and Ohio are ground zero for the opioid addiction epidemic. Their attorney generals were the first ones to file cases against the manufacturers and distributors. There are counties all around the United States in California, West Virginia, and Pennsylvania, New York, as well as cities. There's a punitive class action by an attorney who became addicted to opioid after he was treated for an orthopedic surgery. What I wanted to focus on was the hospitals. Hospitals are involved as both plaintiff and defendant in these actions. As defendants, they are named for their failure to investigate and fill suspicious, and their failure to investigate and their filling of suspicious orders. As plaintiffs, we're starting to see more and more complaints where hospitals are suing defendant manufacturers and distributors of opioids for economic damages. The economic damages claimed are for expanded care required to treat addicted patients and their newborns. These hospitals claim they will have to expend far more for these patients and are not getting fully reimbursed by either private health insurance companies or the federal government, as a disproportionate number of these patients are Medicaid recipients. Under the last bullet, Teamsters and other unions are suing defendants for having to pay for these opioids as part of their health plans, but also for having to provide treatment for opioid addiction as part of their benefit offerings. They allege RICO marketing practices of the defendants who they claim opioids were safe for long-term use and caused these health benefit companies to include them in their prescription offerings. So what's the current status of the opioid litigation? 3 bellwether cases are being scheduled for trial in September of 2019. They include 3 government suits, Summit County, Cayuga County, Ohio, and the city of Cleveland. There are 13 different categories of damages in the bellwether MDLs. I'm going to read you some of the some of the economic damages claimed. Losses caused by decrease in public services due to diversion of funds to address the epidemic. The cost of providing health care and medical care for patients suffering from opioid-related addiction. Costs for training emergency personnel. Costs for providing police, firefighters, and emergency personnel. Costs of naloxone, an opioid antidote. But here's a little bit different. Here there are also property damage being alleged by these municipalities and these government entities. Losses caused by diminished property values, and losses caused by decreased business investment and tax revenue are the more esoteric type of claims being made in the MDL. Bullet 3, the production of the DEA's ARCOS database, which is the prescribing database that the FDA tracks, that the DEA tracks. The information from the ARCOS database has been made available to the judge in the MDL. The purpose, what has happened is it's been the impetus for new defendants being named. Those of us who are watching this closely are concerned that this may allow, this disclosure of market share may be used as a way of bringing the parties to settlement discussions, that they're going to be tagged with the amount of market share they have of the opioids. There's discovery disputes, there's lots of them. Mostly these discovery disputes center on proofs of causation. Plaintiffs do not want to provide any proof of individual or specific causation, not even for the bellwethers. The defendants want to have an opportunity to perform discovery on doctors who claim that they were misled by the industry on the safety of the opioids for long-term use. The defendants clearly believe that their doctors knew what they were prescribing and prescribed them anyway. Defendants also want to be able to conduct discovery on individual plaintiffs and their addiction issues, whether pre-existing or caused by opioids. Clearly, the plaintiff's bar does not want these unsympathetic facts about the plaintiff's addiction. There's an interesting study that suggests that 70% of the opioid plaintiffs had addiction issues prior to being prescribed opioids. So that makes the challenge between the discovery challenge even more important. There are also discovery disputes on whether opioid addiction constitutes a common law statutory nuisance. These decisions are currently pending before Judge Polster in the MDL. Bullet 5, an enterprising group of plaintiffs' lawyers have petitioned the Joint Panel on Multi-District Litigation to establish a separate multi-district proceeding for the newborns of these addicted individuals. This can be seen as by cynical folks as an attempt to circumvent the various unsympathetic facts of the addict's medical histories. Newborns are not to blame for their parents' addiction, yet suffer from a myriad of serious medical conditions from drug abuse. At the hearing, the JPML seemed unlikely to create a special proceeding for the newborn infants and, in fact, rejected this attempt on December 6th. Bullet 6. Who knows? Will there be a widespread settlement? The defendants have dug in their heels. Perhaps Purdue and a couple of manufacturer distributors will settle. Purdue has not been known to try any of the cases. One thing to consider is that there may be an MDL for individuals addicted to opioids after the government reimbursement MDL, which is currently pending, ends. So you may not even see the end of the MDL, the opioid crisis, because after this is decided, you may be seeing individual cases for drug addiction. So is this a model for future government actions? Again, maybe, because if the government makes enough money, you may be seeing them coming after manufacturers and distributors of what they view as problem products. There are many who have suggested that this is just another tobacco, but there are key differences between opioids and tobacco products. Adam?
Thanks, Sonia. So I'm going to quickly hit on innovator liability again. As you recall, the innovator liability issue is when a name brand manufacturer is held liable or sought to be held liable for the consumption of a drug by a consumer who took the generic version of that drug. All over the United States, these claims have been barred. The law does not allow for these claims against name brand manufacturers, but that has changed as of this year and at the end of last year. So in late December last year, the California Supreme Court actually allowed these innovator liability claims to go forward against the brand name manufacturer and held that brand name manufacturers owe a duty of reasonable care to ensure that product labeling includes adequate warnings whether or not the end user is exposed to the brand name drug or its generic equivalent. Likewise, in March of this year, the Massachusetts Supreme Judicial Court held that a brand name manufacturer that controls the contents of the label on a generic drug owes duty to consumers of that generic drug not to act in a reckless disregard of an unreasonable risk of death or grave bodily injury. And so the door is being opened to expose manufacturers of drugs, name brand manufactured drugs, to liability on the basis of Innovator liability. And that's something that we expect to kind of, we'll see more of going forward in the future in reliance on these two California and Massachusetts court cases. The good thing, if there is any silver lining, is that there's always going to be, or generally will be, a specific jurisdictional defense in these cases. So if a plaintiff sues a name brand manufacturer in a state where that name brand manufacturer is not at home, based on the consumption, ingestion of a generic drug, then the name brand manufacturer is not going to be subject, hopefully, I mean, I assume the court gets it right, to specific jurisdiction in that state. The name brand manufacturer has not reached out into that state, has not had any contact into that state. The only one that has is the generic manufacturer. And so to be subject to liability, we expect that those claims are going to have to be filed in the home state of the name brand manufacturer. Sonia?
My last slide has to do with fake drugs, a threat to global industry. These counterfeit drugs are one of the main reasons that we are seeing a growth in drug-resistant microbial or fungal infections. People are becoming more and more susceptible to these superbugs. These infections grow and become resistant because there's simply not enough of the active pharmaceutical ingredient initially to inhibit growth and prevent mutation. These fake counterfeit drugs are costing people lives, and this is going to be a global epidemic if more isn't done to inspect and hold these parties accountable that are making a lot of money, frankly, from fake and counterfeit drugs. And that's the end of our presentation. We have a couple of seconds for some questions, if you have any.
Yeah, so we are at the top of the hour, so I am just going to address this one question that came through the registration process, and it's probably more for Adam. Are Class 3 devices seeing more liability issues than Class 1 or 2, and are implants more of a target for attorneys?
Yeah, sure. That's a great question, and it's actually an issue that I'm facing right now on a case that I'm on. So Class 3 medical devices, as most people know, are devices that have been subjected to the federal, the FDA's pre-market approval process. And so if an implant or a device goes through that process and comes out the other side and receives approval from the FDA, then that is the FDA affirmatively finding that that device is safe and effective. And so what is happening now is, in large part, historically, claims against Class 3 medical devices have been shielded on the basis of preemption. So because the FDA made a finding, the federal government made this finding, then state court plaintiffs can't come in and challenge that finding and say the device is not safe. The issue is that more and more courts are allowing parallel claims to go forward against Class 3 medical devices. And so, yes, there is much more litigation on this. And a parallel claim is simply a state law plaintiff alleging violations of the federal regulations. So they're trying to kind of circumvent the state law preemption, saying, well, you violated federal law and my state allows me to sue for that violation. For instance, there was a case that came out of Baltimore earlier this year where the court found that not all claims were preempted, and the conduct-based claims as opposed to product-based claims, things such as warranty, negligent misrepresentation, failure to train, fraud, those were allowed to go forward against a Class 3 medical device, which is that's pretty significant. That means that device manufacturer now has to go through discovery, expert witnesses, prepare for Dalbert challenges, dispositive motions, which is very expensive. And so it's something that I think we're definitely going to see more of in the future.
Great. Well, thank you. Thank you, Sonia and Adam, for presenting on this topic. With 2019 just around the corner, this will surely help us all prepare. And I appreciate, Adam, that you are in trial up in Philadelphia and so graciously did this from a hotel room. So I do appreciate that as well.
No problem. I enjoyed it.
Great. Thank you. This concludes our webinar.